There are fewer protesters this morning so far, perhaps because it is raining and so gross out. Cindy, send the rain to Georgia. I would that I could. Total number left to release. So, hi everyone, good morning. We're outside the Supreme Court where the court will release one or more opinions from argued cases this term. An opinion is the same thing as a decision. So the court will release one or more decisions from an argued case this term. There are 13 outstanding decisions that the court has not yet released. So we expect to get one or more of those this morning in about 30 minutes. Yep.
How long have you been working at Fox 5?
I have been there since 1 year ago yesterday.
Oh, wow.
Yeah. So right now what I'm doing is we're live streaming from the web with Channel 5, and then here I'm also live streaming with TikTok. And what I do is I walk everyone through all of the opinions as they come down on the Supreme Court's website, which if you want to follow along too, you can just go to supremecourt.gov. And then at the top left, you hit opinions of the court, and then everyone's just going to hit refresh. Yeah, exactly. Opinions of the court will hit refresh right at 11 a.m. Good morning, everyone. Good morning, good morning. Yes? Not my monkey, not my circus. That's one of my mother's favorite sayings. Yes, the Supreme Court added another opinion day tomorrow morning at 10 a.m. So we already know that this is not the final opinion day. And I would not be surprised if they add another day next week, but we'll see how many they get out today and tomorrow. Good morning, good morning. Good morning. We'll see. So there are 13 outstanding decisions that the Supreme Court has not yet released. And there are some pretty significant ones left, not just the abortion case. I know everyone is keeping an eye on that, but there's a major gun rights case that's pending, climate change. There's several biggies. Someone was asking about Torres v. Texas, which we already got. That was a case about this federal law that's called USERRA that was enacted under Congress's war powers under Article 1, and that provides veterans the right to be rehired into their old job when they come back for military service. And that law imposes rules on both private and state employers. And Leroy Torres, who's a Texas state trooper and served in Iraq, he sued Texas for violating that federal law when he didn't get a new position when he returned from his service in Iraq. And Texas was arguing that it was protected from that suit under sovereign immunity. So that's a biggie. My makeup is going to start falling off in a moment in all this rain. It's so gross out. Actually, I'm going to put my head back up because it's gross. Good morning, good morning. Yes, there's a couple dozen protesters right now. It's a good bit of media. Here, I can show you. You can kind of see, well, there's a tree, but you can kind of see what's going on. Good morning, Texas. Is the Roe opinion today? We do not know yet. the way that this goes is the Supreme Court will start releasing the opinions at 10 a.m., but we don't know which or how many opinions we get. So it's a bit of a guessing game, and everybody finds out together at the same time. I'm going to get a towel because everything is getting wet. So, we are live outside the Supreme Court. We have T-minus 24 minutes until the Supreme Court releases one or more decisions from an argued case this term. We're down to the final few days of Supreme Court opinions here. We only have 13 outstanding decisions that the Supreme Court has not yet released. We're expecting some this morning, and we also know that the Supreme Court will release decisions tomorrow morning, so today is not the final day of decisions. And just for those of you who are new, who are watching, the way that this goes. So beginning at 10 a.m., the court will start releasing opinions on their website. If you want to follow along and get them yourself, supremecourt.gov/opinions, or you can just click opinions in the top left of the Supreme Court's website. You can also go to scotusblog.com. We'll be constantly updating and uploading the opinions right as they come in. And the opinions, if there are multiples, which I expect there will be released in 10-minute increments. So the first one will come at 10 a.m., and the second one will come at 10:10, the third at 10:20, the fourth at 10:30, and thereon after that until we're done for the day. Now the question is, how do you know when we're done for the day? And on the Supreme Court's website, under opinions, I'll show you. You can see this is where the opinions are released, and you see this column that has an R number right over here. There will not be an R number if there's still going to be more opinions coming out. Once the court puts in an R number for the day, that means we're done. So if there is no R number, that means we'll be getting at least one more opinion. Now, the other thing about how opinion release goes is they're released in order of reverse seniority of the justices. So whoever goes first for the day, that's the most junior justice with an opinion. So, for example, if Justice Alito has the first opinion for the day, nobody more junior to Justice Alito will have an opinion for the rest of the day. So you can kind of discern who might be next depending on what happens, but that just gives you a little insight into how this process goes. So all of that will begin at 10 a.m. And we're waiting on 13 decisions. Somebody's asking me to explain the climate change case, which I'm happy to do. So at base, this is one of the 13 cases that we have not yet gotten a decision in from the court this term. It's called West Virginia V Epa. And it is about the EPA's authority and regulating greenhouse gases. And it's a huge case about the EPA's authority to regulate greenhouse gases that cause climate change. And so we will see, there's a big jurisdictional issue in that case too, where the court could kind of punt on the issue and not decide the substance. But that is certainly one that we could get today. Basically about whether the EPA has the authority to restrict or even get rid of pollution, try and control pollution that's heating the planet. So that one will be a biggie. Well, right now, the last decision, somebody's asking about tomorrow, the scheduled opinion day for tomorrow. Tomorrow is the last opinion day on the calendar. That does not mean that it will be the final opinion day. In fact, the Supreme Court usually indicates when they will release all of the opinions, the remainder of the opinions. It's raining, guys, so I'm going to have to, constantly. They usually say that they will release all of the opinions, all the remaining opinions. So that has not happened yet, so I would not bank on tomorrow being the final day of opinions. But we do know the Supreme Court will release at least one more opinion on its website. So we have 19 minutes until the Supreme Court will begin doing that, one or more opinions. I expect we'll get multiples this morning. The Supreme Court went into the month of June with a lot of opinions left to get out, over 30, a hefty amount for them to get out before their traditional time that they rise for summer recess, usually right before the July 4th holiday. So there was some conversation about whether they would be able to make that unofficial deadline. Of course, the court can do what it wants. Nobody can tell them what their deadline is for getting out the decisions. So there was some question of whether they could, but they now appear, because of the number of decisions. Last week we got 11. This week so far we've gotten 5. We'll get more today, more tomorrow. Because they've gotten so many out so quickly in June, it appears they are on track to wrap up the term by what would be next week, right before the July 4th holiday weekend. Good morning, Catholic C. Yep, it's going well this morning. There are a group of protesters. They're pretty small so far. It's pretty gross and rainy out, so that would be a pretty strong disincentive for people who aren't members of the press who are out here covering what's happening. But there's small but mighty devoted protesters, mostly on the issue of abortion, on both sides of that issue, who have signs, some megaphones, flags, music. But you guys, it is not just abortion that we're waiting on. I know everyone's waiting on that decision, and of course it's a big one. But we are waiting on multiples this morning. And all of that starts at 10 a.m. on the dot. So let's talk through some of the outstanding decisions from this term. As I just talked about, the major climate change case, that one's called West Virginia v. EPA. Again, that's about the EPA's authority to minimize pollution, regulate greenhouse gases. That could have a huge impact on the EPA and how it goes about trying to combat climate change. And we're still waiting on that one. There's also a a major Second Amendment case out of New York that's called New York State Rifle and Pistol Association v. Bruin, and that case is a major Second Amendment decision. It's perhaps the biggest Second Amendment decision the court has made in over a decade. And back in 2008, the Supreme Court ruled that you have the individual right to keep and bear arms, that's not tied to service in the militia. And that was essentially holding you have the individual right to keep and bear arms in your home for the purpose of self-defense. And this case will determine whether that right extends beyond the home, whether you have the right to keep and bear arms outside the home for the purpose of self-defense. But the specific facts of that case are about a New York regulation that places a burden on individuals who are trying to get a concealed carry permit in the state of New York, and it requires those individuals to show what's called proper cause. And that means something above and beyond just wanting to have the gun. They have to show another reason for needing it or wanting to carry the firearm. And so Second Amendment rights advocates argue that that violates their right to keep and bear arms. Placing that burden on them to have to show proper cause in order to carry a gun violates their Second Amendment rights. They should be able to get the concealed carry permit without that hurdle. And the court seemed inclined to agree with them. There are a number of justices, particularly Justices Kavanaugh, Alito, Gorsuch, Thomas, have talked about needing to reconsider or reiterate our understanding of the Second Amendment and needing to weigh back in on their Second Amendment jurisprudence here and take what, if they go that way in this case, would be a more expansive view of the Second Amendment, the right to keep and bear arms. So it seemed like there were a majority of justices poised to vote to strike down that New York law. And that would have ramifications beyond the state of New York. It wouldn't just strike down New York's law. There are other state laws, including right here in our backyard in Maryland, that have similar additional requirements in order to get a wear and carry, as it's called in Maryland, or a concealed carry permit in those states. In Maryland, you have to show a substantial and good reason to get that permit, and there are a few other states that have similar laws. And so what that decision could do is clarify and expand our understanding of the Second Amendment right, and make it difficult for states to enforce, if not outright strike down, similar laws. So that's a pretty big one. A lot of folks are waiting on that one, and that's actually the oldest undecided case on the Supreme Court's docket. That case was argued in early November. The Supreme Court has already issued decisions in all of its October and all of its November cases. So that one's been pending for a while. That's clearly taking some time. And that usually indicates, when a case takes a long time like that, that usually indicates that there's a disagreement, which, would make sense given what we understand about the jurisprudence of the justices and their reading from their questions during oral argument. So how it works is right after the court hears a case. In this case, they heard this major Second Amendment rights case in early November. They have read all the briefs. They've had oral argument. They then go into their conference room together, and each of them speaks and gives their thoughts, and nobody's allowed to speak twice until everybody speaks once. And they take an initial vote on the way that they think that the case should go. And based on that initial vote, the most senior justice in the majority assigns who writes the opinion. If there's a dissent, if there are 2 or 3 or 4 justices who disagree, then the most senior justice in dissent decides who writes that opinion. And when there is a disagreement, when there is a majority and a dissent, especially on a case like the Second Amendment, where the court so rarely issues Second Amendment decisions and so rarely talks about the Second Amendment, that kind of disagreement can take time to write. Once the opinions are then assigned, the justices begin drafting those opinions. Their clerks begin drafting those opinions. And when there is disagreement, the majority will look at the dissent will look at the majority, and they'll kind of incorporate each other's arguments sometimes in their own writing, or, fine-tune what they're saying in the opinion based on what the other side is saying. And so those decisions sometimes take a little bit longer. That may also be what is happening in Dobbs v. Jackson Women's Health, the abortion rights case. I suspect that's what's happening with Second Amendment. I do not know for sure. But the fact that that case has been pending for so long, since early November, seems to indicate that there is, some additional writing or scrutiny going on in putting together that opinion. So I originally was going to go through some of the major ones that we're waiting on. We can talk about those if you guys have big questions. Oh, yeah, there's an interesting case it's a criminal case about doctors and opioids. It's about whether doctors they're being prosecuted for unlawful prescriptions, whether they should be able to avoid conviction, not get convicted, by arguing that they had a good faith subjective belief to give out the prescriptions for legitimate medical purposes. And so some people refer to that as the pill mill case, but it's called Ruan v. United States, and that's a biggie that we're waiting on as well. So we have just about 10 minutes until the Supreme Court will release one or more decisions. A reminder a reminder of how this goes. So beginning at 10 a.m. in just about 10 minutes, when the Supreme Court begins releasing their decisions, they will release them one at a time, and they will begin releasing them at 10, and then they'll do it in 10-minute increments. So we'll get the first one at 10, and then we won't get the second one until 10:10. If there's a third, 10:20. If there's a fourth, 10:30. If there's a fifth, 10:40. It could take, up to an hour if we're getting a lot of opinions this morning, 5 or 6 opinions. Last week we got 6 on Wednesday. It could take almost an hour to complete that process. And again, they are released in order of reverse seniority of the justices. So the most junior justices get their opinions out first, and then it moves on to the more senior justices of the day. So sometimes we can glean a little bit about maybe who has the next opinion coming down. So all of that's going to kick off in about 9 minutes now. I'm going to keep wiping down all of my electronics because it is just absolutely spitting rain. What a delight. At least it's not hot, as somebody said. And again, a reminder, this is not the last opinion day. We know for sure there will at least be opinions tomorrow morning, and the court has not said that the final opinions will be tomorrow, so I think it's also a good possibility we will get opinions next week as well. But they've got 13 left to get out. And if you want to follow along, go to SCOTUS Blog's website or go to supremecourt.gov and click Opinions of the Court. And you can follow along and hit refresh with all of the Supreme Court reporters. I'm going to drink as much coffee as humanly possible in the next 8 minutes while also talking. Do you guys have any questions about some of the outstanding cases? We have about 8 minutes, T-minus 8 minutes, until we start getting opinions. For those of you also asking about how many cases the Supreme Court takes each term, it has actually decreased over time. Now they take between 60 and 70 cases. It used to be in the 80s. Are they still doing the running of the interns? So a couple of folks have asked about this. They are not. So when the pandemic hit, the Supreme Court went remote like the rest of us and started doing oral arguments remotely and closed the court. And in fact, the courthouse is actually still closed to the public. You can, in the before times, you could go into the Supreme Court and take a tour. You could go in and hear oral argument. In fact, that's the only way that you could ever see the Supreme Court do oral argument was if you actually showed up here, got in line, and went in to watch, because there is no camera inside the Supreme Court. And they closed the building down. Now no one is allowed in except for now the justices and their staff and clerks and members of the press who have a hard pass, which is a very limited number of folks in the press. So folks in the SCOTUS Blog Live blog are asking about what the atmosphere is like. So I'm just going to update them. Rainy and very gross is what I'm telling them. There's about 24 protesters. Capitol Police have lined in between the two fences, perhaps to prevent people hopping the smaller fence like they did earlier. When we were here on Tuesday, 2 individuals hopped this smaller fence right here behind me, if you can see, and they chained themselves, they handcuffed themselves to the taller fence. And then the Supreme Court PIO let us know that actually 3 individuals were arrested for violating, essentially for trespassing, where the Supreme Court marshal has said you cannot go. So I was answering what happened to the running of the interns. Interns are no longer allowed in, but what used to happen on major opinion days, and I used to be one of these interns, is we would get paper copies of the opinions from the Supreme Court press office, and then the interns would run across this plaza back here, run the opinions out to members of the press that are standing here, that were standing on the plaza of the court, so that everyone could read them and then, that it would be a race to see how fast the interns could run to get the opinion out to people, because you had to have a hard paper copy. But now, perhaps more transparent, is they put all of the opinions up on the website right away. So the public gets the opinions in the same way that we do. And you can refresh the Supreme Court's website and read the opinions right away. This is your 5-minute warning, by the way, 5 minutes until the Supreme Court will release one or more opinions from argued cases this term. This is the 5-minute warning. So the running of the interns no longer happens. As sad as that is, that was always a fun tradition that usually happened on the last day of the term, because typically the Supreme Court waits to release the most contentious, most talked about, bigger cases, at least from the public's perspective. Arguably all of the cases are important, but from the public's perspective, the masses, they usually wait till the very end to release those decisions. So no longer the running of the interns, for those of you who are asking. I know it was great fun. It added to the drama of the day, but now the drama of the day is wiping rain off of your computer and hitting refresh while hoping the umbrella holds up at the same time. Does the Supreme Court know who leaked the Dobbs opinion? Not as far as I know. That hasn't been reported. They haven't notified us that they know. My understanding is the investigation is still ongoing from latest reports. And the most recent reports, I believe, were from CNN's Joan Biskupik, who said that the Chief Justice had asked for affidavits. Does it come down at all? Would it come down at all? It would be great if it could come down. Just like be lower. Yeah. Oh, that's amazing. My magnificent camera guy is helping me lower the umbrella. Okay, perfect. That's wonderful.
Is it?
Yeah, thank you. Yeah, no, this is good. Just see if it'll, yeah, perfect. Thank you. We're trying to do as best we can out here in the rain. So what I had most recently heard, read from Joan Biskupik's reporting in CNN, was that the Chief Justice had asked the clerks for affidavits and for phone records as a part of the investigation. So, T-minus 3 minutes until we get major opinions, until we get opinions. I don't know for sure whether we'll get any of the major ones that I suspect you all are waiting to hear, but it's possible. We'll get one or more opinions beginning at 10 a.m. 2 minutes. Again, if you want to follow along, go to the Supreme Court's website or go to SCOTUS blog. Can you guys hear the protesters? I can show you a little bit. There's about, 30 or so protesters. Now it looks like police officers have lined up around the protesters. Yeah, officers have lined up around the police officers, and Capitol police officers have now lined in between the two fences. So, we're going to have opinions from the court in 2 minutes. Again, major cases, criminal law, climate change, guns, of course, abortion. There's lots of interesting issues, and there are 13 outstanding decisions that we will get at least one of in 1 minute. Why did Capitol Police assist the Supreme Court? That is a good question. I suspect there actually weren't Capitol Police lining the fence. They patrol the area somewhat, but they weren't lining the fence until yesterday. All right, you guys, so we have under 1 minute until the Supreme Court will release one or more decisions. There's a police dog going by me. I'm not sure if you guys can see it. And we'll talk you through each of them, all right? So again, at 10 o'clock, the first one comes down. If there are multiples, I'll tell you right away. And the next one will get released at 10:10. So you and I will have a few minutes to look at the opinion, explain what it is, talk about it, make guesses about what's coming next. It's 10 o'clock on the dot, so I'm going to start hitting refresh on the Supreme Court's website. Again, if you want to join, supremecourt.gov/opinions, or just go to SCOTUS blog, where they will post the opinion as soon as it comes down. So I'm just hitting refresh on the Supreme Court's website right now, hoping my computer doesn't fits out in the rain, which so far it's holding up, so it's good. Just hitting refresh, and we'll get the first opinion from the Supreme Court momentarily. Again, there are 13 outstanding decisions from the court. The first one is Berger v. North Carolina State Conference of the NAACP. This is about intervention in a voting rights issue. Justice Gorsuch delivered the opinion of the court, joined by Roberts, Thomas, Breyer, Alito, Kagan, Kavanaugh, and Barrett. Justice Sotomayor filed a dissenting opinion. So this is an 8-1 decision, and the Supreme Court has held North Carolina's legislative leaders are entitled to intervene in this litigation. Okay, so this is a North Carolina passed a voter ID law, and the state chapter of the NAACP sued, arguing that it violates the Federal Voting Rights Act. All right, so the state attorney general, who is a Democrat, is defending the law in court. Nonetheless, Republican leaders in the state, they want to intervene in this litigation to be able to defend the law. And the Fourth Circuit did not allow the Republican legislators to intervene, and the Supreme Court just said that they are, in fact, allowed to intervene. The rain is getting harder here. Again, this is about a North Carolina voter ID law. And the Supreme Court has just ruled 8-1 that the GOP lawmakers in North Carolina can intervene in the litigation to defend this state voter ID law. The NAACP, again, is challenging the law. The North Carolina Attorney General, who is a Democrat, is defending the law, but the legislators want to intervene anyway, and the Supreme Court says they can do that. All right, and this is not the final opinion of the day. The opinion is from Justice Gorsuch, so we know we will not be getting an opinion from Justices Brett Kavanaugh or Amy Coney Barrett, who are both more junior than him. As I explained earlier, the opinions today get released in order of reverse seniority. So let's take a look briefly at the opinion itself, at the majority opinion. It's a 37-page PDF. Justice Gorsuch opens with, at the heart of this lawsuit lies a challenge to the constitutionality of a North Carolina election law. But the merits of that dispute are not before us, only an antecedent question of civil procedure. Are two leaders of North Carolina's state legislature entitled to participate in the case under the Federal Rules of Civil Procedure 24A2, if you're curious? And so the Supreme Court has said that the Republican state lawmakers in the state of North Carolina can intervene in the case. That's a legal term that means that they can step into the case and they can make their own arguments defending North Carolina's state voter ID law. So the Supreme Court has ruled 8-1 that they are, in fact, allowed to do that. And that was an 8-1 decision. Justice Sotomayor was in dissent. So again, North Carolina passed this law. The NAACP is challenging this state voter ID law, but the Democratic Attorney General for the state of North Carolina is defending the law. But the Supreme Court has just said that the Republican lawmakers can also step in and defend the law as well. So it wasn't that the law was going undefended, it's that the Republican lawmakers wanted to step in and also defend the law and make their own arguments about defending the law. And Justice Gorsuch says right at the top of the decision, this is a straight civil procedure question, whether they have the ability to legally intervene. And intervene, again, is a legal term, and it just means step into the case that's already happening between two parties and make your own arguments. And it's a civil procedure question. There are rules of civil procedure that govern how these cases work in federal courts. There's a book of them. Lawyers have to take a test about them. And they govern everything that happens. And what Justice Gorsuch said, along with 8 of the 7 additional justices, 8 of the court's total justices, was that the federal rules of civil procedure allow these GOP legislators to step in and intervene. They want to make their own arguments defending the law. So let's skip down to Justice Sonia Sotomayor's dissent here, just to see what she says. She's got about a 14-page dissent, and she opens with, when an individual or entity moves to intervene in a pending lawsuit under this federal rule of civil procedure, a federal court is not authorized to grant that motion if an existing party to the case adequately represents the movant's interests. Again, a reminder here, the AG was already defending the law. The GOP legislators wanted to come in and defend the law as well, but the AG was already defending the law. The AG is a Democrat. The state leaders were Republicans. So she continues, today, however, the court holds that two leaders in North Carolina's General Assembly are entitled to intervene as a matter of right to represent the state's interest in defending the constitutionality of the North Carolina law, even though that interest is already being ably pursued on the state's behalf by an existing state party to the litigation. And she says the court's decision is wrong for two reasons. First, the court goes astray by creating a presumption that a state is inadequately represented in federal court unless whomever the state law designates as a state representative is allowed to intervene. Second, the court errs by implying that the Attorney General's defense of the constitutionality of the voting law at issue here fell below a minimal standard of adequacy. I respectfully dissent. So that's really the general breakdown here. We've seen similar fights about who is allowed to step in and defend these laws. We've seen it with abortion laws. When sometimes there's an election that happens during while a law is being passed, or there's a change in power, and who wants to challenge that law and who wants to defend that law and who is interested on either side sometimes shifts over the course of a litigation. And sometimes there are elections that happen in the middle of a litigation that change who in the state is representing the individuals who would defend the law or who would choose not to enforce the law. So we've seen this type of issue come up, but as Justice Gorsuch says at the top, and 7 justices agree with him, this is just a straight interpretation of the federal rules of civil procedure and that they allow these GOP lawmakers to step in. So again, just stepping back, the decision is 8-1, that it's about a North Carolina state voter ID law that was passed. The NAACP is challenging this state voter ID law, saying that it's unconstitutional, and the state attorney general in North Carolina was already defending the law in court, but that state attorney general is a Democrat. And so these state leaders who are members of the Republican Party also wanted to join in on the lawsuit to be able to defend the constitutionality of the law, perhaps making different arguments. And so the court decided 8-1 that they are allowed to step in and do that under the federal rules of civil procedure. We have 2 minutes until we get the next decision. Two minutes until we get the decision. The next decision from the Supreme Court. Again, we will be getting at least one more. And checking in on the crowd. Still going, still 30 or so, and the police officers are still around them. So we have T-minus 1 minute until the next decision. So again, we get these every 10 minutes. Justice Neil Gorsuch had this opinion, so the next one will be either another Justice Gorsuch opinion or someone more senior than him on the bench. Justice Gorsuch, of course, is the first President Trump appointee. He's the most senior President Trump appointee of the 3 on the court, so we will not be getting an opinion from Justice Amy Coney Barrett or Justice Brett Kavanaugh, but we could be getting opinions from Sotomayor, Kagan, Alito, Thomas, Breyer, Roberts. Anyone more senior, or we could get another Justice Gorsuch opinion. It's possible. Or per curiam, as Rob points out. We could also get a per curiam decision. They seem to be doing per curiam decisions last. Yes, there are now 12 outstanding decisions from the Supreme Court. Good. Okay, it's 10:10. I'm going to begin refreshing the Supreme Court's website, but also drinking coffee. Can you guys hear me okay with all of the yelling in the background? For those asking if we're going to get the Roe v. Wade opinion, that case is called Dobbs, and I just don't know yet. I'll find out right along with you. We don't know which opinions we'll get. We don't know how many opinions we'll get. We don't know if the big one will drop today. But if you want to follow along too, it's on the Supreme Court's website. We're all just hitting refresh. Okay. The second opinion is Nance v. Ward. It's Justice Kagan. Delivered the opinion of the court. This is an Eighth Amendment case about methods of execution and challenging that. Justice Kagan delivered the opinion of the court. She is joined by Roberts, Breyer, Sotomayor, Kavanaugh. Barrett filed a dissenting opinion, joined by Thomas, Alito, and Gorsuch. So this is a 5-4 decision with Kavanaugh and Roberts in the majority. Section 1983, the court holds. Section 1983 remains an appropriate vehicle for a prisoner's method of execution claim, whereas here the prisoner proposes an alternative method not authorized by the state's death penalty statute. So this is a challenge that's made by a Georgia death row prisoner to the state's method of lethal injection. Michael Nance says that the injection method would violate the Eighth Amendment. The Eighth Amendment, of course, bans cruel and unusual punishment. And the question is, what procedural mechanism that Nance needs to use, and prisoners like Nance have to use in order to bring a method of execution challenge, to challenge the method that's being used for their execution. And the two possibilities in this case is they need to bring these sorts of challenges under the federal habeas statute, or prisoners can bring these challenges under 1983. And bringing them under 1983 is just more expansive, more beneficial, more helpful for prisoners in this case, and gives them a little bit more room. So the lower court actually ruled in favor of the state, rejecting Nance's attempt to use Section 1983, but as the Supreme Court just held, Section 1983 is the proper mechanism. So, the Supreme Court has sided with the death row prisoner here out of Georgia in a case about what procedural mechanism he needs to use in order to challenge the method of execution in Georgia. He's challenging the method of lethal injection. And the Supreme Court has said that it's proper to use something called a 1983 action, and that prisoners are not limited to federal habeas laws to bring those types of challenges. Again, this opinion, second opinion of the day, it is not the final one. It is from Justice Kagan. Let's look at the opinion briefly. It is a short opinion, 22 pages in total, for including the majority and the dissent, 22 pages for the PDF. And Justice Kagan opens the opinion by saying, in several recent decisions, the court has set out rules for challenging a state's proposed method of execution under the Eighth Amendment. Again, he was making an Eighth Amendment challenge here to lethal injection. The Eighth Amendment bans cruel and unusual punishment. And she continues, to prevail on such a claim, a prisoner must identify a readily available alternative method of execution that would significantly reduce the risk of severe pain. So when a prisoner makes these types of challenges to method of execution, they have to propose their own alternative, firing squad, or some other alternative. In order to challenge it, they have to make a propose an alternative as a part of that challenge. She continues, in doing so, the prisoner is not confined to proposing a method authorized by the executing state's law. He may instead ask for a method used in other states. So execution under state law is generally governed by that state's. They have set out the methods that they will use, and states are allowed to choose different methods for themselves. And so some states might allow one method and other states might not allow that method. And so what Justice Kagan is saying here, along with the majority of the court, is when the prisoner makes those challenges, they can step outside of that state's law, here it's Georgia, and ask for an alternative method outside of that state law. She continues, this case concerns the procedural vehicle appropriate for a prisoner's method of execution claim. We've held that such a claim can go forward under Section 1983. We've talked about Section 1983 lawsuits before, rather than in habeas when the alternative method proposed is already under state law. Now the prisoner has identified an alternative method that's not so authorized, and the question is whether 1983 is still the proper vehicle. She holds, and the court holds, that it is. This is a 5-4 split. That's not a split that we often see from this court. Chief Justice Roberts and Justice Kavanaugh have joined the court's 3 liberal justices in the majority. And Amy Coney Barrett, Alito, Thomas, and Gorsuch are in dissent. I'm just going to skip briefly to their dissent here, which is, again, brief. It's just 4 pages. Justice Barrett writing for the 4 conservatives, saying, an inmate must bring a method of execution challenge in federal habeas application rather than Section 1983 if a grant of relief to the inmate would necessarily bar the execution. Under this criterion, Michael Nance would proceed in habeas because a judgment in his favor would necessarily bar the state from executing him. She's arguing that makes habeas the right vehicle for Nance's 8th Amendment challenge. So that's the second opinion of the day. Just a brief recap. So the first decision we got from the Supreme Court was Justice Neil Gorsuch. That was an 8-1 decision. That was about a state voter ID law and who can intervene to defend that law. So there was a state voter ID law passed in North Carolina that NAACP is challenging, arguing that it's unconstitutional. The state is already defending the law. The Democratic Attorney General in North Carolina is defending the law, but these Republican state lawmakers, state leaders, wanted to intervene to also defend the law, perhaps to make different arguments, and defend the law against the NAACP's lawsuit saying it's unconstitutional. And the Supreme Court ruled a straight civil procedure decision that those GOP lawmakers can intervene in that lawsuit and they can defend it. That was an 8-1 decision with Justice Sonia Sotomayor in dissent. The second opinion is about a prisoner on death row in Georgia who's challenging the method of execution, lethal injection. And the Supreme Court said that that challenge and the procedural mechanism for that challenge in this case, under the specific facts of this case, can go through under Section 1983 and it doesn't have to go through federal habeas law. So we will get at least one more opinion today in 2 minutes. For those of you who have been on for a while, we've talked about 1983 lawsuits before. Those are the lawsuits that are used to challenge law enforcement when you're saying that your civil rights have been violated. All right, 2 minutes until we get the next decision. Again, we go in order of reverse seniority. So we are now up to Justice Kagan. It was right after Gorsuch. She was President Obama's second appointee. So we are done with opinions from President Trump's appointees for the day. The only one we got was from Justice Gorsuch. The next opinion will be either from Justice Kagan or someone more senior than her on the court, which leaves Justice Sonia Sotomayor, Justice Alito, Justice Thomas, Justice Breyer, or Chief Justice Roberts. All right, 1 minute until we get the next opinion. It stopped raining, actually. I can take my hood down. I don't know. It actually has not stopped raining. Oh, well. At least I don't have to stop. I don't have to wipe down my computer as much. All right. Next opinion is coming down in 1 minute. We've gotten 2 so far today. See if you have questions. All right. It's 10:20. We are getting the next opinion now. Okay. We're hitting refresh on the Supreme Court's website, and we will get the next opinion. Okay, the next opinion, Vega v. Tico. That is a Justice Alito decision. Here, the Supreme Court holds that a violation of the Miranda rules does not provide a basis for a 1983 claim. We're talking about 1983 lawsuits again. I'll explain more in depth in a moment. This is a Justice Alito opinion. He's joined by Chief Justice Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. Justice Kagan filed a dissent, joined by Breyer and Sotomayor. So this is a 6-3 decision, right along ideological lines. So the question in this case is, if the police fail to give you Miranda warnings, and then the government uses your unmirandized confession, a confession that you make with failed Miranda warnings, if they use that against you in court, can you later sue the police officers under 1983 for violating your Fifth Amendment rights? Here, the Ninth Amendment ruled in favor of the criminal suspect, Tico, but the Supreme Court has reversed the Ninth Circuit. That's a sentence I say often. And again, holds that a violation of Miranda rules does not provide a basis for a 1983 claim. It is a 26-page PDF, pretty brief opinion. Justice Alito, delivering the opinion of the court, says this case presents the question of whether a plaintiff can sue a police officer under 1983 based on the allegedly improper admission of an unmirandized statement in a criminal prosecution. And the case came out of the interrogation of this man named Terrence Tico by the Los Angeles County Sheriff's deputy. And the deputy, Deputy Vega, questioned Tico at his place of employment and didn't give him a Miranda warning. And Tico was prosecuted. His confession was admitted into evidence, but the jury returned a verdict of not guilty. So Tico then sued Vega under 1983, and the United States Court of Appeals for the Ninth Circuit held that Tico's unmirandized statement provided a valid basis for the 1983 claim. And Justice Alito writes, we now reject this extension of our Miranda case law. So again, the Supreme Court sides against the criminal suspect here, who was found not guilty. Tico was interrogated at his place of employment by a sheriff's deputy, and that statement that he gave, this was in Los Angeles County, that statement that he gave was used in trial. He was prosecuted. His confession was admitted into evidence, but the jury returned a verdict of not guilty. He sued, saying that violated his Fifth Amendment right, and the Supreme Court just said you cannot sue under 1983, making that allegation. That is a 6-3 decision along ideological lines. I just read from Justice Alito's majority opinion. Let's briefly skip down to Justice Kagan's dissent and take a look at that. A brief dissent, 5 pages. She says the court's decision in Miranda v. Arizona affords well-known protections to suspects who are interrogated by police while in custody. Those protections derive from the Constitution. Dickerson v. United States tells us in no uncertain terms that Miranda is a constitutional rule, and that rule grants the corresponding right. If police fail to give you Miranda warnings to a suspect before interrogating him, then he is generally entitled to have any resulting confession excluded from his trial. From those facts, only one conclusion can follow, that Miranda's protections are a right secured by the Constitution under the federal civil rights statute. Yet the court today says otherwise. It holds that Miranda is not a constitutional right enforceable through a 1983 lawsuit. So, an interesting note here, Miranda actually comes up in a lot of questioning when we're talking about Roe v. Wade. I'll explain why it comes up with Roe v. Wade in just a second. Three minutes until the next decision. All right, so why does Miranda come up? So the Supreme Court just decided that if a police officer fails to give a suspect Miranda warnings and the government uses the suspect's un-Mirandized statements against him in court, his confession that was not Mirandized, the suspect cannot sue the officer for violating his Fifth Amendment right to self-incrimination. You have the Fifth Amendment right against self-incrimination, but you cannot sue an officer for violating that, for not Mirandizing you and then using your confession in court. Now, the reason why Miranda comes up is because we talk about Miranda being decided. The word Miranda and the concept and the words that are used in a Miranda warning are not in the Constitution. That was, part of the court's holding in Miranda, and so similar to Roe, privacy is not in the Constitution, and the line of cases that Roe v. Wade comes from is not in the Constitution in the same way that the words of the Miranda warning are not. And so often nominees who are coming before the Senate are asked about Miranda during confirmation. In fact, Justice Kavanaugh was asked about Miranda, as were several other justices who are on the court right now. And Kavanaugh used Miranda in his answer on Roe. And he said that the court's 1992 decision in Casey affirmed Roe, making it precedent on precedent. Similarly, he said Miranda was reaffirmed by Rehnquist, who had fervently criticized Miranda. So that's an interesting point. Okay, it is 10:30. We are now getting the next decision. All right. We will get at least one more decision today. The decision will be someone more senior than Justice Alito, or another Justice Alito decision, which just leaves Breyer, Thomas, and Roberts. So I'm just refreshing to get the next opinion. This is the final opinion of the day. This is the gun case. This is the Second Amendment decision. Hey, Doug, we just got the Second Amendment decision, just FYI. We just got the Second Amendment decision, just FYI. Okay, I'm having an error pulling it up. Bear with me. The file's not working. This is the major Second Amendment case we were talking about. It's called New York State Rifle Association, Pistol v. Bruin. New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. The Supreme Court has struck down New York's regulation on concealed carry permits, saying that it violates the right to keep and bear arms in public for self-defense. This opinion was delivered by Justice Thomas. He's joined by Roberts, Alito, Gorsuch, Kavanaugh, and Barrett. Alito filed a concurring opinion. Justice Kavanaugh filed a concurring opinion, joined by Roberts. Barrett filed a concurring opinion, joined by Breyer. Barrett filed a concurring opinion. Breyer filed a dissenting opinion, also joined by Sotomayor and Kagan. Again, this is the major Second Amendment decision that we have been waiting for out of New York. The court has struck down New York's proper cause requirement in order to get a concealed carry permit, holding that it violates the 14th and the Second Amendment right to keep and bear arms in public for for self-defense. This takes an expansive view of the Second Amendment. The court has previously held that you have the right to keep and bear arms in your home for the purpose of self-defense. Today's decision expands that right beyond the home, holding that you have the right to keep and bear arms outside the home for the purpose of self-defense. Justice Thomas delivers the opinion of the court. This is a 135-page opinion. And he opens with the court's landmark decision in D.C. v. Heller and the follow-on case, McDonald, saying, we recognize that the Second and 14th Amendment protects the right of ordinary law-abiding citizens to possess a handgun in the home for self-defense. In this case, petitioners and respondents agree that ordinary law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We, too, agree and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protects an individual right to carry a handgun for self-defense outside the home. I'm just going to get a tweet out for a moment, and then I'll talk you through the decision. This is a major Second Amendment decision out of the court where they have struck down the Supreme Court has just decided a major Second Amendment decision holding that the right to keep and bear arms is an individual right to carry a handgun for self-defense outside the home. Yeah, that's what I'm talking about right now. Yep.
Thank you. Thanks a lot.
Yeah. Okay, so Thomas has written that this extends the right to keep and bear arms that the court has previously held in D.C. v. Heller to have a gun inside your home for the purpose of self-defense. Now the court holds that you have the individual Second Amendment right to carry a handgun for self-defense outside the home. Again, this was about a New York law that required individuals to show proper cause in order to get a concealed carry permit. And the Supreme Court has struck down that law. Second Amendment advocates were arguing that that additional burden, requiring them to show proper cause, burdened their Second Amendment right to keep and bear arms. The Supreme Court agreed, saying you do have the individual Second Amendment right to keep and bear arms to carry a handgun outside the home for self-defense. So they have struck down the New York law. There are other similar state laws, including right here in Maryland. Maryland requires showing a substantial and good reason in order to get a wear and carry permit. So are they going to want me to go live for this one, or are we out of? Will you talk to them and I'll keep talking through the decision? So continuing with Justice Thomas's decision. Again, the Supreme Court has decided a major Second Amendment case. The court rarely weighs in on the Second Amendment here, but you have the right to carry a handgun outside the home for the purpose of self-defense. They have struck down a New York regulation that would require you to show proper cause in order to get a concealed carry permit. Again, this is a major Second Amendment decision from the Supreme Court, where Justice Thomas writes, they're going to go to me live. All right, guys, so I'm going to have to go on TV live. So what I'm going to do is I'm going to put you in my ear, and you're just going to hear me talk about it. And we're going to do both at the same time. And then I'll be right back. So I'm going to stay with you. But I'm also going to have to talk on TV at the same time. We're going to talk through the decision together. It's a hefty one. It's 135 pages. It's Channel 5 if you're in D.C. You can go to fox5dc.com/live. So I'm just going to have to stand up, and we're going to go live here.
They're going to take a quick hit from you.
Yeah.
I told them to give us 5 minutes to get ready.
Okay. I'm just going to turn on all my stuff here, and I'm going to keep reading the decision. So Justice Thomas says the parties nevertheless dispute whether New York's licensing regime respects the constitutional right to carry handguns publicly for self-defense. In 43 states, the government issues license to carry based on objective criteria, but in 6 states, including New York and Maryland, the government further conditions issuance of a license to carry on a citizen's showing of some additional special need. Because the state of New York issues public carry license only when applicants demonstrate a special need for self-defense, we conclude the state's licensing regime violates the Constitution. Again, major Second Amendment rights decision here. I'm going to have to go on TV, so you guys just hang with me. We're going to talk about it. I'll answer your questions. We'll go through the decision. Hey, Chris, I can hear you. Can you hear me? What time? Now? Okay. All right, guys. Yeah. So where do you want me? I can just hold this. Oh, stand by. Good morning. That's right. We just got the final opinion of the day, which is one of the major ones that we've been waiting on. The Supreme Court has struck down a New York law that put an additional burden on those who wanted to get a concealed carry permit. This is a major Second Amendment decision where the Supreme Court has just held that you have the right to carry a handgun outside the home for the purpose of self-defense. In the famous case D.C. v. Heller back in 2008, the Supreme Court held you have the right to have that gun inside the home for the purpose of self-defense. Today, in an opinion by Justice Thomas for a 6-3 court along ideological lines, Justice Thomas writes that New York's burden on those who want to get a concealed carry permit is unconstitutional and that you have the Second Amendment right to keep and bear arms, to carry a handgun outside the home for the purpose of self-defense. This is important right here in our backyard because, as Justice Thomas points out at the beginning of the opinion, 43 states just require objective criteria to get a concealed carry permit, but there are 6 states who make these additional requirements on individuals who want to carry a gun, like New York did, something beyond just wanting to carry a gun, and Maryland is one of them. And in New York, the showing was you had to show proper cause to get a concealed carry permit. In Maryland, you have to show what's called a good and substantial reason. Maryland is one of 6 states that places that additional burden on individuals in order to carry a gun. So today's decision will certainly impact Maryland's law. Attorney General Brian Frosh said he was anticipating that will change things in Maryland, and we'll keep you updated. But again, a major Second Amendment decision today here at the Supreme Court. I'm going to keep reading through the opinion. Okay. All right. I'm just going to keep reading through the opinion. Hi, guys. All right. So, okay. All right. So, again, the Supreme Court has just released a major Second Amendment decision. Justice Thomas, writing for the court's majority, holds that you have the right to carry a handgun for self-defense outside the home. So I'm just going to go through, again, the opinion is hefty here. It's 135 pages. Interesting that I just Control F to see if Uvalde was listed in this decision. The Supreme Court, let's see if it, yes, in Justice Breyer's dissent, he writes, the dangers posed by firearms can take many forms. Newspapers report mass shootings occurring at the Entertainment District in Philadelphia, Pennsylvania, an elementary school in Uvalde, Texas, a supermarket in Buffalo. He lists a number of them: Aurora, Charleston, Orlando. I just was curious if that was incorporated into the decision, and it was. All right, so going back to Justice Thomas's majority opinion. The Supreme Court has held you have the right to carry a handgun outside your home, striking down a New York gun regulation that would require you to show proper cause in order to get a concealed carry permit. Let's see if I can bring this down. Okay, I'm just going to cover myself a little bit more. All right, so I'm just going to keep reading through Justice Thomas's decision here. There are a number of writings on this. Again, this Justice Thomas delivered the opinion of the court, joined by Roberts, Alito, Gorsuch, Kavanaugh, and Barrett. Justices Kavanaugh and Barrett take a particular view of the Second Amendment, looking at the history, text, and tradition of the Second Amendment, which is not the traditional method of analyzing laws that would impose on the Second Amendment. So it'll be interesting to see what the court writes about how we analyze those laws and what the test is when we're looking at those that infringe on the right to keep and bear arms. So again, this is about New York State's public carry restriction on handguns since the early 20th century. It's raining more here now, so I'm going to put my jacket back on. Thomas indicates that it's, I'm reading from Amy in the live blog here, indicates that it's settled that places like polling places and courthouses were sensitive places where arms carrying could be prohibited, consistent with the Second Amendment. So now we're talking about the test. So the Supreme Court has rejected the two-part approach. Here, I'll put on so you guys can hear me a little bit better. So the Supreme Court has rejected this two-part test that's used by courts of appeals in Second Amendment cases. And Thomas writes, in keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government will have to show, Thomas says, that a gun regulation is consistent with the nation's historical tradition of firearm regulation. This test, Thomas adds, accords with how we protect other constitutional rights. The Thomas opinion indicates that it's settled that places like polling places and courthouses were sensitive places where arms carrying could be prohibited, consistent with the Second Amendment, and courts can analogize to similar sensitive places, he adds. Thomas explains nothing in the Second Amendment distinguishes between home and public with respect to the right to keep and bear arms. None of the historical limitations on the right to bear arms approach New York's proper cause requirement because none operated to prevent law-abiding citizens with ordinary self-defense needs from carrying arms in public for that purpose. So, again, this is a hefty opinion, 135. For those just joining, the Supreme Court has just decided a major Second Amendment decision holding that you have the right to carry a handgun outside the home for the purpose of self-defense and striking down New York's concealed carry permit regime that required you to show proper cause in order to get a concealed carry permit. Justice Thomas writes, the Second Amendment standard accords with how we protect other constitutional rights. Take, for instance, the freedom of speech in the First Amendment, to which Heller repeatedly compared to the right to keep and bear arms. In that context, when the government restricts speech, the government bears the burden of proving the constitutionality of its actions. Just going through the opinion here again, it's 135 pages. There are multiple writings. This is the final opinion of the day. For those who are curious, we're not getting any more today. I believe we got 4 today, so we're down to 9 outstanding from this term. We will be getting more decisions tomorrow morning. Still going through Justice Thomas's majority opinion, hitting page 70. It's still going. Okay. All right. Justice Alito writes separately to concur. He addresses the dissent, saying much of the dissent seems designed to obscure the specific question that the court has decided, and therefore it may be helpful to provide a succinct summary of what we have actually held. In District of Columbia v. Heller, the court concluded that the Second Amendment protects the right to keep a handgun in the home for self-defense. Heller found that the amendment codified a pre-existing right, and that this right was regarded at the time of the amendment's adoption as rooted in the natural right of resistance and self-preservation, the inherent right of self-defense, explained in the Second Amendment right, is central to the Second Amendment right. He continues, although Heller concerned the possession of a handgun in the home, the key point that we decided was that the people, not just members of the militia, have the right to use a firearm to defend themselves. And because many people face a serious risk of lethal violence when they venture outside their homes, the Second Amendment was understood at the time of adoption to apply under those circumstances. The court's exhaustive historical survey establishes that point very clearly, and today's decision therefore holds that a state may not enforce a law, like New York's Sullivan Law, that effectively prevents a law-abiding resident from carrying a gun for this purpose. That is all we decide, Alito says. He continues for another 10 pages or so. Justice Kavanaugh, joined by the Chief, also concurs. The court employs and elaborates on the text, history, and tradition tests that Heller and McDonald require for evaluating whether a government regulation infringes on the Second Amendment right to possess and carry guns for self-defense. Justice Kavanaugh has written on this before, suggesting that the court needs to clarify that this is the test for laws that would infringe on the Second Amendment, text, history, and tradition. I join the court's opinion, and I write separately to underscore 2 important points about the limits of the court's decision. First, the court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense. In particular, the court's decision does not affect the existing licensing regimes known as shall-issue regimes that are employed in 43 states. Second, as Heller and McDonald established, and the court today again explains, the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. Properly interpreted, the Second Amendment allows a variety of gun regulations. As Justice Scalia wrote in his opinion for Heller, this is a famous line from Heller. Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, this is from Scalia, but Kavanaugh's quoting it in his concurrence. The Second Amendment right is not unlimited. Commentators and courts routinely explain that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. Nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of firearms. That was a brief two-page opinion from Justice Kavanaugh, joined by the Chief, to highlight that section from Justice Scalia's decision in Heller. Justice Barrett also writes separately to concur, to highlight two methodological points that the court does not resolve. First, the court does not conclusively determine the manner and circumstances in which post-ratification practice may bear on the original meaning of the Constitution. Second, and relatedly, the court avoids another ongoing scholarly debate on whether courts should primarily rely on the prevailing understanding of an individual right when the 14th Amendment was ratified in 1868, or when the Bill of Rights was ratified in 1791. Now, on page 84 of the PDF, we get to Justice Breyer's dissent, joined by Sotomayor and Kagan. Again, this decision was along ideological lines. If you're just joining, this is a major Second Amendment decision from the Supreme Court, where they have held that you have the right to carry a handgun outside the home for the purpose of self-defense, and they have struck down a New York concealed carry permit regime that requires individuals to show proper cause to get a concealed carry permit, something above and beyond just wanting to have it. Justice Breyer opens with, in 2020, 45,222 Americans were killed by firearms. Since the start of the year in 2022, there have been 277 reported mass shootings, an average of more than one per day. Gun violence has now surpassed motor vehicle crashes as the leading cause of death among children and adolescents. Many states have tried to address some of the dangers of gun violence just described by passing laws that limit in various ways who may purchase, carry, or use firearms of different kinds. The court today severely burdens states' efforts to do so. It invokes the Second Amendment to strike down a New York law regulating the public carriage of concealed handguns. In my view, that decision rests upon several serious mistakes. The primary difference between the court's view and mine is that I believe the Second Amendment allows states to take account of the serious problems posed by gun violence that I have just described. I fear the court's interpretation ignores these significant dangers and leaves states without ability to address them. Okay. All right, guys. So that's the decision. It's a 6-3 decision. We got 4 decisions today. I'll do a quick recap for you guys, and then I got to go. All right. So the first decision of the day was out of North Carolina. It's about a voter ID law out of North Carolina. The NAACP is challenging that law, filed a lawsuit saying it's unconstitutional. And the state attorney general in North Carolina, who is a Democrat, was already defending the law, but there was a group of Republican legislators who wanted to intervene to also defend the state voter ID law. The Supreme Court ruled 8-1 that they were allowed to intervene in that case and defend the state voter ID law, even though it was already being defended by the attorney general for the state. In the second opinion, a man in Georgia on death row was challenging the method of execution, and the Supreme Court said that those challenges for when you're challenging the method of execution, the procedural mechanism that you have to use, the law that you have to use, the way that you have to go about doing it, was the way that he was trying to do it. It was under Section 1983, and that took him more, that sided with the prisoner in that case. In the third decision, the Supreme Court said that if a police officer does not give you your Miranda warnings, and then your confession is used against you in your prosecution and in court, and that violates your Fifth Amendment rights, you cannot sue the officer for violating your Fifth Amendment right against self-incrimination. And that decision was 6-3. And then finally, the Supreme Court has struck down a New York gun control law that required people to show proper cause and has held that you have the right to carry a handgun outside the home for the purpose of self-defense. So 4 opinions today. We now have 9 outstanding decisions. Tomorrow morning, the Supreme Court will again release 1 or more decisions beginning at 10 a.m. Of the 9 remaining, we are still waiting on abortion, of course. We're still waiting on a major climate change case, criminal law, religious speech. There's several cases that are outstanding, 9 in fact, and we'll get at least 1 more of those tomorrow morning at 10 a.m. But for today, a major Second Amendment decision out of the court. Not unexpected, but significant nonetheless, striking down New York's concealed carry regime and holding that you have the Second Amendment right to keep and bear arms outside your home for the purpose of self-defense. All right, friends, that's it for now. I will be back tomorrow morning at 10 a.m. I will certainly be doing a TikTok about it. Thank you for joining, everyone.
Thanks for having us.
Wow.
We get the live show.
All right. So what I have to do now is go do my show, but then I suspect I'm going to be back out here I suspect I'm going to be in the 4, 5, and 6 out here, but maybe they'll let me front it in-house. Okay, I'll turn